Supplemented daily. Item number 1.
May physical or similar. If petitioner is in custody, Miller 37.
Yes.
May please not similar. Petition is in custody 37 2025 for the initial Miller Commission of Offence under Section 3314 corresponding to 457 IPC and 3096 corresponding to 394 Miller IPC. In the meanwhile, Miller charge sheet has already been submitted. The charge sheet is with me, Miller. T110, 2 corresponding to 395 Miller, turn to 395. Miller, in the meanwhile, Miller, all the theft items were recovered from petitioner along with other 4 accused persons, Miller. So far as the recovery of present petitioner is concerned, Miller, 8,000 and one necklace, Miller. And he's in custody, Miller, the 3 days of purchase. No criminal anti-statement.
You have been identified in the
Yes, that is my complicity only. I don't know. First offender, you lost any stringent condition.
Since when you are in custody?
No, the 30/2025.
देखिए 400
P31 quota 457, P10 quota 393, P114 organized.
Oh, what about the criminal antecedents?
No,
He is a man, local man or
local
outside?
man.
This custody is from 37/2025. क्या नाम कौन है?
Tushar.
तुषार बांशोर लिखा है जी क्या बोले लोग होगी सत्यनारायण सत्य तुषार बांशोर लिखा है क्या शिफ्ट है
Tushar boy and Banchur is in one person. Son of Lord Satyanarayana boy, residence of Noah Sarsara, PS Sadar, this purpose.
Are the land council for the petitioner land council for the state? The land council for the petitioner has produced the certified copy of the FIR charge sheet and the statements of the witnesses and other documents which have taken on record. He submits that the petitioner is in judicial custody since 37/2025. And in the meantime, on completion of investigation, charges have been submitted under section 331 bracket 4, 310 bracket 2 and 111 bracket 4 of BNS. And the stolen articles have already been recovered And so far as the petitioner is concerned, it is the prosecution case. What was recovered from you?
8,000 and one gold necklace.
It is the prosecution case that cash of rupees 8,000,
8,000
one gold necklace
necklace.
was seized from the possession of the petitioner. We further suggest that the petitioner is having criminal antecedent and he is a local man, and therefore there is no chance of absconding. And the their application may be favorably considered. And counsel for this opposed the case for this and argued content is that the petitioner has been identified the T.I. Barrett. However, he has not disputed the submission made by the land and counsel for the appellant that the petitioner is having no criminal antecedent. Considering the submission made by the land and counsel for the respective parties, nature of the petition against the petitioner, the pretension to be self-custody, since he has no criminal antecedent and the investigation is already completed. I'm inclined to release the petitioner on bail subject to condition that he shall not indulge in any criminal activity and appear before the London trial court on which date to which the case will be posted for trial. Violation of any terms and conditions of until cancellation.
Item 2.
To the commercial quantity, the child may not be happy or dispose of by and not unable to.
City criminal antecedent. Yes, next.
Item 3.
Please, your lordship. My lord, the petition is requested from 25 my lord. 25. My bail petition, my lord, was rejected by a courted bench when no evidence was collected. Now the evidence has been collected, my lord. All the victim and the mother I have filed all the certified copy of the witnesses. The victim statement at that time, the lordship has rejected it because the statement during investigation. Now, trial has commenced, my lord, and your lordship will kindly see the statement of the victim and the mother, which I have filed. They have not resigned from the statement, and accused in jail custody, my lord, from 25, the informant has appeared through his counsel.
Mr. Roy,
Sir,
it's a case under POCSO Act, the notice has to go.
notice has already issued and the other lawyer has appeared for the informant.
Where is that?
My lord, I am for the informant.
Akashdeep Mahanti.
He is present very much, my lord.
I am for the informant.
You are Mr. Akashdeep Mahanti.
My lord.
So the victim has supported the prosecution case.
Victim has supported the prosecution case. Yes, my lord. But
she is 13 years of age.
Yes, my lord. But my lord,
Class 8 student, 13 years, supported the prosecution case of rape. So why bail will be granted to you?
My lord, your lordship may kindly see the evidence of the victim.
I have seen it.
In the further proceedings, she has denied. Victim statement, my lord, देखिए, Para 7, my lord.
So 6th August 2025, he stated that I know the accused
Yes, my lord.
and stated that this accused committed this. Then something happened and all on a sudden, after 4 months, he changed the verse.
Yes, my lord.
So whether that second version is to be accepted or the first version, it is to be decided by the trial.
I'm not entering, my lord. I am speaking that now the statement which I have already costed for 1 year.
For what purpose that recall application was allowed?
Recall of certain questions were not.
Evidence was complete and cross-examination was complete. Why she was allowed to recall? Because to help the defense.
My lord, I have the matter is something that what your lordship has marked it as in settled by the parties.
This is not a case for settlement.
No,
This
that is not that.
Committed
I am arguing, my lord, that I am in custody for 1 year.
All right.
1 year of custody, more answer nahi, my lord. I have no answer.
Earlier rejected by this court in BLAPL number 091 of 2025. Mr. Ravi Kumar Roy, land counsel appearing for the petitioner, submitted that in the trial court, the victim has been examined, so also the other material witnesses. And at this stage, there is no chance of tampering with the evidence. Referring to the evidence of the victim who has been examined as PW6, it is stated that though the victim supported the prosecution case regarding commission of rape on her, but in the cross-examination on recall, she stated that she could not identify the person who committed the alleged act of sexual assault on her due to darkness. And she heard from the outsider that it was the petitioner committed the act. The land counsel argued that in view of such contradictory statements of the victim and for the taking into account the period of detention of the petitioner in judicial custody for more than 1 year, the bail application may be favorably reconsidered. What do you say, Mr. Counsel, for the informant?
My lord, I have no objection regarding
The learned counsel for the informant submitted that in view of the settlement between the parties, he has no objection to the grant of bail to the petitioner. What do you say? Appear kalani notice kono. What is your submission?
Statement is there and subsequent cross-examination in the paragraph 5.
Are you opposing the bail application? The learned counsel for the state oppose the prayer for bail, considering the age of the victim to be 13 years, and since he has supported the prosecution case, the examination in chief, I am not inclined to release the petitioner on bail, and taking into account the nature and gravity of the offense, the learned trial courts shall do well to expedite the trial. Yes, next.
Item 4.
May I please your lordship? I am in VC, my lord. My lord, this is a case under section 302, 201, 34 of IPC. And the case is of 2014, my lord. And in one of the in this case, one of the co-accused person who has been arrested earlier, he faced the trial, and trial has already been commenced. And during trial, none of the prosecution witnesses have supported the case of the prosecution, and accordingly, the co-accused has been acquitted from the case, Your Honor. But subsequently, the present petitioner has been arrested, and he is under custody since 19/6/2024. I have filed all the depositions of the witnesses who have.
What happened when you are now facing trial?
My lord,
So how many witnesses have been examined?
my lord, 3 numbers of witnesses have been examined, but after filing of this bail application, my lord,
Who are they?
the informant and 2 eyewitnesses, Your Honor.
What is the deposition copies?
No, my lord, I have not filed because
File.
Oh.
The Lieutenant Counsel for the petitioner submits that the petitioner was an absconder, and the co-accused persons who faced trial have been acquitted, and the petitioner was taken into custody on 19/6/2024. In the meantime, 3 witnesses, material witnesses, have been examined in the trial court, and he may be given some time to produce the certified copy of the deposition of those witnesses. Lest this matter, after entering so before the assigned bench, the Land Counsel for the petitioner supplied the deposition copies and supplied copies to the Land Counsel for the state. Yes.
village mail.
Item 5.
May I plead the Lordship? Lordship, the present petitioner retained in custody since 15th March 2024, Lordship. The offence under section 498/304/2/406 for Decree Act, Lordship. The sum total story of the prosecution and Lordship is the informal law is written report before the Bhogarai police station with an allegation that marriage was solemnized since last 12 years back, Lordship.
Who is the petitioner?
Bhaskar Chandra Behra.
No. How is related to
Husband, Lordship.
So marriage is 12 years back.
Marriage is 12 years back.
Okay. Yes. Then.
And subsequently, she deceased Rachana peacefully resided with her husband, and there was a quarrel between them as per the affair, Lordship. But subsequently, on 15/3/2024, the informant heard that she was murdered. And cause of death, shock and suffocation, Lordship. And because she committed.
It's a case of death by burn injury.
Lordship.
So, what are the materials against you?
Materials, Lordship, as per the case of the prosecution, the present petitioner set the fire. But some witnesses have been examined, 10 witnesses have been examined, they have not implicated the present petitioner.
10 witnesses been examined means where?
And during the trial, Lordship.
So, where is the deposition copies?
I have not filed, Lordship.
File it. The London Counsel for the petitioner submitted that trial has already commenced and 10 witnesses have been examined. Let the Land Counsel for the petitioner produce the certified copy of deposition of all such witnesses and give copies thereof to the Land Counsel for the state matters to adjourn after ensuing Xmas holiday. Yes, next.
Item 6.
It's a case of section 7 and 12 of PC Act ballot. And ballot, both the petitioners, I think, ballot in custody since 14/11/2025. On the ballot petitioner was working as secretary of Mahasakti Weavers Cooperative Society and Nimna block under Ulunda block.
Trap case.
Trap case.
Give it really.
15/11/2025.
I have given the instructions.
Yeah.
ଦିଟା ଯାକ ଦିଟା ଅଛି ଦିଟା ଜଣେ ହଉଛି first one is Deputy Director Textiles Subarnapur, co-accused is Secretary Mahashakti WCS.
ସତ୍ୟାନନ୍ଦ ବେହେରା କଣ କିଏ?
ସତ୍ୟାନନ୍ଦ ବେହେରା ହଉଛନ୍ତି Deputy Director Textiles Subarnapur. ସିଏ ନଉଥିଲେ ଟଙ୍କା ସେକ୍ରେଟାରୀ ମହାଶକ୍ତି WCS ର ଉଲୁଣ୍ଡା ମାଧ୍ୟମରେ। 7 and 12 ଲାଗିଛି 36,000 ଟଙ୍କା ନଉଥିଲେ ସିଏ।
ରମାକାନ୍ତ ମେହେର ଥ୍ରୁରେ।
ହଁ ରମାକାନ୍ତ ମେହେର ଥ୍ରୁରେ ନଉଥିଲେ ସତ୍ୟାନନ୍ଦ ବେହେରା।
The learned counsel, Mr. T.P. Tharlan, senior advocate for the petitioner, submits that petitioner was the whole lecture in code he
is the secretary.
code lecture in paragraph 2.
ତାଙ୍କର ସେକେଣ୍ଡ ଆଇଟମ ଟା ଲିପି ଦଳଙ୍କର।
ନାଇଁ ଏଇ ଯୋଉ ସତ୍ୟନାରାୟଣ ବେହେରା କିଏ?
ସତ୍ୟାନନ୍ଦ ବେହେରାର my learned friend Mr. ସମ୍ବିତ ମହାନ୍ତି is here.
Yes, Mr. Mahanti.
Milord, page paragraph 3. Assistant Director Textile.
Let Mr. Sambit Mahanti submit that the petitioner code lecture here.
Paragraph 3. Milord.
Read the in the title.
Fourth line.
Acha. The petitioner was serving as assistant director of textiles again, and is in judicial custody since 15/11/2025. He further submits that it's a draft case, and in the meantime, investigation has made substantial progress, and there is no chance of tampering with the evidence or absconding of the petitioner. As the petitioner is a government servant, and therefore the bail application may be favorably considered. Mr. The learned counsel for the Vigilance Department, standing counsel for the Vigilance Department, has filed the
Instructions received from the IO.
The file instruction received from the IO to the effect that no further remand of the petitioner is required, and no custodial interrogation is also required. And during investigation, it was ascertained that there is no vigilance case registered against the petitioner. No other vigilance case has been registered against the petitioner. However, he has mentioned that the present case is under investigation, and voice sample of the petitioner is yet to be collected for examination of voice stenography analysis. And further mentioned that the investigation is under progress, and if the petitioner is enlarged on bail, is likely he may tamper with the evidence and influence the witnesses. Stop. The instruction produced by the learned counsel is taken on record. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the progress of investigation, I'm inclined to release the petitioner on bail subject to condition that he shall cooperate with investigation and appear before the investigating officer as and when required on being receipt of notice from the IO, and he shall not try to tamper with the evidence or influence the witnesses, and he shall appear before the learned trial court on his date to which he has posted. Violation of any term and condition shall entail cancellation of bail. Mr. Sanjay Das, learned standing counsel. এইটার আপন কোটারে ফাইল করছেন 12,525 ওটা নেক্সট আইটম ওইটারে আপনাদের অবজেকশনটা দিন
ଦେଇଛି এটা ବି ଦେଇଛି ଦେଇଦିଅ
এটা সেই রাইটে লেখাই তো আচ্ছা
ଆଜ୍ଞା
এটা খালি লেখিবে মিস্টার
5,525 ସିଏ ଥିଲେ ସେକ୍ରେଟାରୀ ମହାଶକ୍ତି WCS
Whoever's cooperative society.
Whoever's Cooperative Society.
File the memo of appearance taken on record. Submits that the petitioner is the
Secretary Mahashakti Whoever's
full
cooperative.
lecture
Paragraph 7. Yes.
Secretary
Mahashakti Whoever's
Cooperative Society Nimna under Ulunda block of Suvarnapur district. And custody since one so parties of Samanvay. Same terms and conditions. That allowed.
To cooperate in the investigation appearing.
Yes, that is.
Item 7.
Item 7, let's wait there for item.
Land counsel for the petitioner 6 for an adjournment. You have received the case diary. Land counsel for the state submit that he has not received the case diary. It appears that the trial has commenced and
Comments below 26 witnesses have been examined.
you have submitted that deposition copies.
Some of the witnesses.
All right, it will after entering to winter holiday plus. Yes, next.
Item 8.
18 minor 52 police exercise at 120 liter ID liquor has been seized. The custody since 1/11/2025.
What about the criminal antecedent?
No antecedent.
Are the land counsel for the petitioner and counsel for the state considering the submission that by the land counsel for the petitioner or the petitioner is in judicial custody since 1/11/25. And the young boy and the investigation has made substantial progress and the offense is traveled by magistrate. And after hearing the land counsel for the state, I am inclined to release the petitioner on bail allowed.
Oblige.
Item 9.
And here in this case, my lord, all the accused person released on bail, my lord. Except the present petitioners before your lordship. One of the other.
My lord, the present petitioner is history sheeter and the petitioner has number of criminal antecedent. I have a glance to the list of dates. List of dates. See.
Yes.
The petitioner arrested and taken to custody in connection with different cases. Dated 13/8/2018.
No. How many cases?
That part I have to obtain instruction.
Only 2 cases, my lord. The petitioner number 1, Lord, you must 12246. He has only 2 cases.
Counsel for the state submits that though he has received the case diary, but he may be given some time to obtain instruction relating to the criminal antecedent against the petition. Place this matter on such and such date. Yes, with status, yes.
Next item, your lordship at last occasion, your lordship was directed to get the criminal antecedent.
Yes, I have already furnished the criminal antecedent. Petition number 1 has 29 criminal antecedent. In response to that criminal antecedent, petitioner number 1 has filed a comprehensive affidavit where he has mentioned about only 3.
I mean, pardon my lord. The present petitioner had been to Supreme Court, my lord, and the order lordship can have a glance. Already he has served half of the punishment in all the cases.
Before the last benches, next.
Item 10.
Matter was listed before your lordship 3 months before my lord and was not listed any other court my lord. Lordship may fix a date my lord.
Yes, next.
Item 10.
Alert. N. Miller charge sheet has been filed under section 376 2N and other offences. I have submitted filing the certified copy of the 164 statement. Your charge sheet has been filed and
Where is the charge sheet copy?
I have filed it as charge sheet and 164 statement. There is one.
Our age is 24 years.
Yes, 24, 25 years. And petitioner is 26 years.
Yes, Mr.
The rejection of the place here is only 164 supporting the fixation.
ସେ କହିଛି ଯେ ଏମିତି ଯାଇକି ରହିଲୁ ବୋଲି ଏକାଠି ହୋଟେଲରେ ଗୋଟେ ରୁମରେ
Major
she's a married lady
married
and her husband was taken into judicial custody in connection with the case and then this man
Yes.
for that I would help you and then they stayed there in that room for 5 days and physical relations were there. For the London Council for the Petitioner and Council for the State. The London Council for the Petitioner filed the certified copy of the charge sheet and the statement of the victim recorded under section 164 CRPC. Which are taken on considering the submission made by the Land Council for the petition that the petitioner is in judicial custody
since 23/9.
2025. Charge sheet has been submitted under section 366-506, 376-2N, 423-43 of the IPC. After going through the 164 CRPC statement of the victim who is married lady, aged over 24 years, and other materials available on the court, and giving the Land Council for the State, and inclined to believe the petitioner on bail subject to condition that he shall not try to come in contact with the victim, shall not try to tamper with the evidence, and appear before the trial court on each day if the case has been posted. He shall not indulge in any criminal activities, violation of any terms and conditions or until cancellation of bail allowed.
Item 11.
May I please your lordship. Lordship, the allegation against the petitioner is under section 394 of IPC. My lord, their name do not appear in FIR. No test identification parade has been conducted to establish their identity. The entire the conviction is only based upon the confessional statement given by the prime accused Rocky, alias Arbaz Khan. Since when you are in study? My lord, 19/7/2025. My lord, the prime accused has already been released on bail. 19/7. My lord. Where have you stated that? My lord, on para 11. Para 11. Here's what you say. FIR is against that Rocky. If you come to that annexure 1, Rocky is only named and the petitioners have been implicated on the confessional statement of who accused. Offense, this very offense charge sheet has been submitted. My lord, 394, or it has become 395. My lord, I don't have further instruction, but the charge sheet has been submitted on 9/2/2025. No, charge sheet you have mentioned the charge sheet submitted. But what is the offense here? The FIR was lodged under 390, under section 390. My lord, also the prime accused has released on bail. Are the Latin counsel for the petitioner and counsel for the state? And counsel for the petitioner submit that the petitioners are young lawyers and they are in judicial custody since 19/7/2025. And in the meantime, one completion of investigation charge sheet has been submitted. The petitioners have not been named in the first information report, and only one, Rocky, has been named therein. And the implication of the petitioner is based on confessional statement of said Rocky before the police. And Rocky has been directed to be released on bail. My lord. Where is that order? My lord, on annexure 3, page 12. Annexure 3, my lord. Page 12. Directed to be released on bail. And the copy of the bail order has been annexed to the bail application. Considering the submission by the London Council for the respective parties in the period of detention of the petitioner judicial custody, there is and immediately who are accused on bail are inclined to release the petitioners on bail, allowed shall not indulge in any criminal activities. Appears before trial on the stage. Yes, allowed. Much obliged.
Item 12. That's the offense under section 21B of NDPS Act. Petitioner is in custody since 27 September 2025 and seized ground shooter is in 45 grams, which is below commercial quantity, my lord. And the petitioner is a local man and no chance of absconding. And investigation is already completed.
Yes, Mr. 45 grams. Any criminal antecedent?
One case, but not similar. One case, one criminal antecedent, he was in bail. Not similar antecedent.
Same similar case?
No.
Then what is that offense, sir? Where have you stated that he has been granted bail and that there is a criminal?
Page 13, petitioner is involved in another case. Page 13, rejection order, annexure 2.
13 in the petitioner.
Rejection order, my lord.
Oh, it
Rejection order ଲେଖା ହେଇଛି petitioner is involved in another case.
who line ଟା କହୁନାହାନ୍ତି?
8 line, last and 8 line.
Page 12 na
13, my lord.
13 start is to release the petitioner on bail. Accordingly, the application for bail stands rejected.
My lord, बार sir.
Here तो पूछ लो.
Sorry, my lord, 12. Petitioner is
The petitioner is involved in another case. Heard the land counsel for the petitioner and counsel for the state. Considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since 27/2025 and prosecution report has been submitted. Final PR has been submitted or not? This is the provisional PR. You have no idea.
My lord, no idea.
Uh,
Investigation has
and the quantity of brown sugar stated to have been seized from the possession of the petitioner is lesser than commercial quantity, and therefore bar under section 37 of the NDPS Act is not applicable. And the petitioner is having one criminal antecedent, but not of similar nature, in which he is on bail. After hearing the land counsel for the state, I am inclined to release the petitioner on bail allowed.
Item 13. Please, Your Lordship. Lordship, it's an offence under section 318(4) of BNS, Lordship. In the meantime, charge sheet is already submitted, and the allegation against the petitioner is that the petitioner is
318(4) cheating and dishonestly inducing delivery of property. Acha.
420.
And 3.5. The amount involved, madam, किसे?
Amount as per allegation, amount is 4,65,000.
4,65,000.
Lordship, may kindly peruse the statement of the witnesses. They have stated that ସେଥିରୁ ସେମାନେ କିଛି କିଛି ପଇସା ଆମକୁ already payment କରି ଦେଇଛନ୍ତି.
କୋଉଠି ଅଛି ଦେଇଛନ୍ତି?
Lordship, page number 17.
79.
17. Their statement under section 180 of BNS.
So ଟଙ୍କା ମଧ୍ୟରୁ ସେମାନେ ସର୍ବମୋଟ ଆଚ୍ଛା ଏତିକି ଟଙ୍କା 200 ସୁଝି ସାରିଛନ୍ତି ଅଛନ୍ତି.
Page number 18, 19 ରେ ବି ଅଛି ସେମାନେ ସବୁ payment କରି ଦେଇଛନ୍ତି already.
Hard खुशबू पानी लग land council appearing through virtual house. So the looks like the petitioner is in judicial custody since February
13/9/2024.
13/9/2025, and he has been charged seated on the section 318(4), 3(5) of BNS, and as per charge sheet, the cheating amount is rupees 4,65,000, but the statements of the witnesses will indicate that some amount has been refunded to them. Land counsel further submits that so magistrate and law officers and the petitioner is a local man. Therefore, their application will be favorably considered. Land counsel for the state authority there for the considering the submission made by the land counsel for the respective parties, the nature of application was petition. Since the offenses are traveled by magistrate, keeping in view the period of detention, petition is in judicial custody. I mean, trying to release petitioner on bail allowed.
Much obliged, sir. Item 14.
P02 and other offenses. Is diary of criminal antecedent and
Item 15.
a lot of paying for that. Paying for that. Adjournment. What is your name?
Amarman, Aman.
A-man, P6 for an adjournment. Have you received the case diary? Mr. Nayak, case diary ଅଛି?
15 that is the Sanjay.
15 number.
Yes, 15.
ELAPL 12255. ନାଇଁ
Case ସେଟା ସଞ୍ଜୟ
ଆରେ ଯାହାର ସବୁ ଆପଣ କୁଆଡେ ଗଲେ କୁଆଡେ ପଚାରୁଛି କେସ୍ ଡାଏରୀ ଅଛି ନା ନାଇଁ କଣ ଆଚ୍ଛା ସିଡି ଆଉ ସିଏ ପ୍ରଡ୍ୟୁସ କରିବାକୁ ନେକ୍ସଟ
Item 16.
matter corporates 5-10-23.
302 case ଅଛି
302. In the meantime, matter out of 21, 9 have been examined.
where is the deposition copies?
Copy ଟା ମୁଁ ଦେଇନାହିଁ.
Pilarian counsel for the petitioner submits that he has instruction that
Rejection order force.
and some witnesses have been examined
9
in the trial court and he may be given some time to produce the certified copy of the petition of all the witnesses examined so far in the trial court. So this matter on such and such date, the deposition copies shall be produced and copies thereof shall also be provided to the land council for the state. Land council, land council for the state saying that he has received the case diary. Yes.
Mine.
Item 17.
May I please, Your Lords? Now, this is the second bail application of the present petition, my lord. Earlier bail application, my lord, because of the criminal antecedents, this court was not inclined. Therefore,
Which
there
is
was
your earlier bail application?
8897 of 25 men. It was withdrawn with liberty to move after filing of charge sheet, my lord. Now,
charge sheet now has been submitted.
My lord.
Where is the charge sheet?
Yes, my lord. The charge sheet, my lord, along with the comprehensive affidavit, my lord, I have filed. Sir, my lord, prosecution cases, my lord.
Have you given the copies to the state comprehensive affidavit? How many cases you have got?
16 antecedents, ma'am. 16 antecedents.
16 antecedents.
My lord, 10 to 12 cases, my lord, are involving offense under section 21 of MMDR Act and 12 of OMPPS Act.
So you have mentioned that in all those cases you have been granted bail.
Mine.
Where is the bail order copies?
1480 lakhs is involved and the 16 antecedent is there in the rejection order. In the rejection order, the
no, he has filed also. He has mentioned in the comprehensive affidavit regarding the status of those cases and in most of the cases it is mentioned that he has been granted bail. So you verify because he is not producing the. Will you produce or will ask the state to verify?
I have got some of the copies, my lord, in some cases and.
No, you can say that you cannot, then state can prove. The learning counsel for the petitioner finds a copy of the charge sheet with a memo which is taken on record. And since there are number of criminal antecedents against the petitioner, he has filed a comprehensive affidavit relating to the status of such cases. And in most of the cases, it is mentioned that the petitioner has been granted bail. However, since the bail orders are not produced, the learning counsel for the state seeks some time to obtain instruction on the additional on the comprehensive affidavit filed by the petitioner. put up this matter on such answer. These are taken on that paper.
Item 18.
Offense under section 20B2C above commercial from date earlier rejected by a coordinate bench in the second round of the proceeding.
Have you got the case diary? Get the case diary and criminal investigation. Yes.
Repeat.
Item 19.
Commercial one.
99 kg 870.
Right. CDCA.
Item 20.
C02.
Nine.
Sheet. No, 9. City of Criminal Antecedent Act. After the winter holidays. Next.
Item 21.
May I pray one thing, madam? The case where it has been committed, the PO has retired, and for the last 8 months, there is no progress in the trial. Though commitment has been made, the PO has retired. Let also may call for a report.
The guardian counsel for the petitioner submitted that since last 8 months there is no presiding officer, and even though the case has been committed to the court of session, due to absence of the presiding officer, there is no progress of the case. Let a report be forwarded from the concerned court, and
Commitment has been done in the year 2024.
file will fail to the land register itself and send email to the Swanson. Yes, next. Police.
Item 21.
May I please, Your Worship? Alleged offences are under section 109 of BNSS, read with 25 and 27 of Acts Act, my lord. My lord, the petitioner so much surrendered before the Lorraine Trial Court and has been in custody since 14/10/2025, my lord. My lord, allegation is that the petitioner has attacked the husband of the petitioner by means of a sword, my lord. In the meantime, my lord, charge sheet has already been submitted.
Already charge sheet.
My lord, annexed 5.
How many blows you have given?
My lord,
How many blows you have given?
my lord, as per the FIR, my lord, ତାର ବାମ ହାତକୁ ହାଣିଲା ଏବଂ several injuries ବୋଲି ଅଛି.
Where is the injury report?
My lord, page number 43, my lord. 43, my lord. Not rejection order shows that nature is grievous.
And you are in custody since when?
25/10/2025, my lord. Sorry, my lord, 14/10/2025.
How many cases you have got?
No antecedent, my lord.
Here, what do you say?
Was released on anticipatory bail, subject to verification of antecedent and injury previous then sir.
For the guardian counsel for the petitioner and counsel for the state, considering the submission made by the counsel for the petition that the petitioner is in judicial custody since 14/10/2025, and in the meantime, on completion of investigation, charge sheet has been submitted under section 109 bracket 1 of the BNS and section 25 bracket 1 bracket small a and 27 of the Arms Act. And after going through the statement of the injured, his injury report, and hearing the land counsel for the state, I'm inclined to leave the petitioner on bail subject to condition that the petitioner shall not try to come in contact with the injured or tamper any evidence, violation of any terms and conditions, or enter cancellation of the law.
Item 22. 22, my please, Lordship.
Yes.
Lordship, custody since 17/10/2025. Allegation is 75 to BNS along with 62 my lord. It is 354 along with 511. 354 along with 511. Lord, in the meantime, charge sheet has been submitted. The victim is a married lady, and the petitioner is the nearby neighbor. Petitioner is a neighbor, my lord.
Neighbor of the victim.
My lord.
Where is her statement? Who has lost the affair?
The affair has been lost by Singha to the husband, my lord.
No, the victim herself for her.
Singha to the victim, my lord.
Huh?
My lord, on the date
Victim
of
lost it.
my lord.
Victim lost the affair. Why are you telling that husband lost the affair?
I got confused by the name.
Okay, so Amugar so and so.
His husband was walking outside. There was a consent relationship between the victim and the petitioner, my lord. On the date of incident, the son was present. And he saw the illicit act between the parties. And then after the affair arises.
But the land council for the petitioner, land council for the state. Consider the submission made by the land council for the petitioner that the petitioner is in judicial custody since 17/10/2025. And in the meantime, on completion of investigation, the charge sheet has been submitted under section 126 bracket 2, 351 bracket 2, 79, 331 bracket 4, and 75 bracket 2 for PNS. And after going through the statement of the victim and other materials available on record, I am inclined to release the petition of subject to condition that the petitioner shall not try to come in contact with the victim, shall not try to tamper with the evidence, appear before the trial court on the state, violation of any terms and conditions shall enter cancellation of the law.
Item 23.
109 offense along with other offences, and the present petitioner are custody since 14/7/2025. In the meantime, charge sheet was submitted on 10/10/2025. And also in the charge sheet copy, because all the injury is simple in nature.
From you get simple in nature. So many injuries are there. First and fracture on the.
I have given the charge sheet copy. I have given the charge sheet copy, and on the charge sheet copy.
He was referred
The
to
running
Hospital.
price is 13 and 14.
Discharge summary reveals subdural hemorrhage, fracture mandibular, fracture condyle, ZMC fracture, elbow injury.
And that about the charge sheet patient, the above. The body injury of charge sheet copy also. Written there is simple nature, all opinion of injury inflicted on the body in the Lakhinder Naik. All injury are lacerated wound and simple nature caused by blood. Running page 10 in the charge sheet.
He has produced a injury report indicates two injuries are there, simple in nature, but was referred to SC Medical College Hospital.
That is in respect of Lulu alias Dhirendra Dev. Two injured persons are there. One is Lakshmidhar Naik and another is Lulu alias Dhirendra Dev. So far as Dhirendra Dev is concerned, the injuries are simple in nature. Lakshmidhar Naik's injury report reveals she was referred to Ashwini Hospital.
That is discharge.
Discharge
Order
injuries are
page 12.
previous.
Page 12.
One is this Lakshmidhar, other is
Dhirendra Dev.
Dhirendra to goti injury simple ଅଛି.
Simple.
Are the Learned Council for the petitioner and counsel for the state. Considering the submission made by the Learned Council for the petitioners, as the petitioners are in judicial for full
14/7.
since 14/7
2025.
and in the meantime, on the completion of investigation, charge sheet has been submitted under section 126 bracket 3, 296, 118 bracket 1, 109 bracket 1, 351 bracket 2, 308 bracket 4, and 3 bracket 5 of BMS. And after going through the injury reports of the two injured persons, which indicates about the simple injury sustained by the injured persons, and after viewing the counsel for the state, I am inclined to release the petitioner on bail allowed. Yes, next. Item 24, yes.
Item 24.
9 kg.
9
kg of ganja. 20B, 2B, no criminal antecedent knowledge. In the meantime, final form already been submitted.
11/3/25 ରୁ ଅଛନ୍ତି।
मतलब 29/10/2025, 11/3 incident and FIR, PR, subsequently arrested on 29/10/2025, 9 kg.
देखो, custodial 11/3/25. The quantity of ganja seized is 11/19/20.
29/10/2025. 29/10/2025. मतलब ये जो डेट चार्ट रे भी लिखी थी पी रे आउ सब भितरे रे
अच्छा, the custody since 29/10/25 and quantity of ganja is
9 kg.
9 kg lesser than commercial one. Criminal antecedent after giving the land council, it is allowed. Next slide.
Obliged.
Item 25.
Maybe also. No, the presentation of focus is 7925 my lord. No, the informed laws the FIR against the present picture under section 69 of BNS law. Now, allegation the presentation of the physical relationship with the victim was promise of marriage my lord. Now, kindly see the medical document.
Last statement of the achieve.
Yes.
Awesome.
The president is not capable of the medical report is same.
Let us see him say. Statement first, then. What was your age?
23.
All of people guys last year would do only the one. All out of this point was changed. So some for the particles, these were more of fully more. Or the Learned Council for the petitioner and council for the state. Considering this submission, made by the land council for the petitioner that the petitioner is an official custody. 7/9/25, and he has been charge sheeted under section 69 BNS. After going to the statement of the victim, recorded under section 183 of BNSS. We did about 15 price 23 years. Another material available on the court. And after hearing the land council for the state, land to the petition around the subject condition. Shall not try to come in contact with the victim. Shall not try and to review evidence. Appears before the trial for an state. The case of the innovation of any township condition surrendered and so. I'm just coming within 2 months.
Item 26.
Please. This is a petition by the father-in-law for the death of the daughter-in-law, my lord.
Yes.
Father-in-law is there because this lordship as petitioner, the death of the daughter-in-law in an unnatural manner after a short period of marriage. For that purpose, case was instituted under 103, and subsequently during course of submission of charge sheet in the meanwhile, that 103 has been deleted and 108 has been added along with 316. Besides 80 and 85 of the banis.
No, where is the charge sheet copy?
Charge sheet copy, my lord.
You are having that copy?
Yes, I have.
Pass on. This petitioner is the father-in-law.
Miller.
What is the name of the deceased?
Deceased name is
Jinnat Fatma. Jinnat Fatma.
So the marriage took place when?
marriage on 28th April 2025. And she
April 25.
And died on 15th of August 2025.
And
Death was due to
cause of death?
Antemortem hanging. And as per the postmortem report, there is no external injury of any sort, except the ligature marks available on the.
What are the materials against this father-in-law?
The family members have stated that after the marriage she was subjected to cruelty demanding dowry, and on the date of incident the present petitioner scolded her, for which she bolted the door from inside and did not open.
Who is that? Which is that statement?
Statement is my father's statement is there, Ramjan Ali Ansari and
Ramjan.
Mirza Jabir Beg.
Achha, Mirza. Who is Mirza?
Mirza is the brother-in-law and he reached the spot fast.
Ramjan is the informant.
Ramjan is the informant.
More name Ramjan Ali Ansari. Muaji apna pair swanso ମୋର ଝିଅର ବାହାଘର ତା ସାଙ୍ଗରେ ହୋଇଥିଲା। ପୁଅ ଦାବି ମୁତାବକ ଜିନିଷ ପତ୍ର ଦେଇଥିଲେ। ବାହାଘରର କିଛି ଦିନ ପରେ ଝିଅ ପ୍ରତି ଅକଥନୀୟ ଅତ୍ୟାଚାର ହେଲା। ଶ୍ୱଶୁର ଲୋକ ଅଧିକ ଯୌତୁକ ପାଇଁ ଏଭଳି ଭାବର ଅତ୍ୟାଚାର କରିଚାଲିଲେ। ଘଟଣାକୁ ଝିଅକୁ ଅନେକ ଜଣାଇଛି। ସମାଧାନ କରିବାକୁ ପଳେଇଛି 15 ତାରିଖରେ ପରିସ୍ଥିତି ଉପରେ ସ୍ତ୍ରୀ ମୋତେ କହିଲେ ଅନେକ ବାର ବଳିଲେଣି ସେ ଫୋନକୁ ଆଚ୍ଛା କଲ୍ କରିଲେଣି ହେଲେ ସେ ଫୋନକୁ ରିସିଭ୍ କରୁନା। ତାପରେ ବଡ଼ ଜ୍ୱାଇଁକୁ ମଧ୍ୟ ଫୋନ କଲି ସେ ଜିନକୁ କଲ୍ କରିଛନ୍ତି କି ନାହିଁ। ସେ ମୋତେ କହିଲେ शेख सबीर आलम
and solve କରିଥିଲା କୋଉଟା ଜିନକୁ ତାର ବାପା ଖାଇବା ପିଇବା ପାଇଁ କଣ ଦାବି କରିଥିଲେ ତ ସେ ଘର ଭିତରେ ଆସି ଘର କବାଟ ଖୋଲିନାହାନ୍ତି ଆଉ ମଧ୍ୟ କହିଲେ ଜିନକୁ ଟିକେ ଫୋନ କରି ବୁଝେଇଦବା ସେ କହିଲେ ଯେ ସେ ଗୋଟେ ଗାଡି ଭଡା ନେଇ ଜଣସୁ ଯାଉଛନ୍ତି ତାଙ୍କ ଯିବା ପାଇଁ 3ଟାରେ ପହଞ୍ଚିଲା ବେଳକୁ ଦେଖିଲା ବେଳକୁ ଜିନ ଖଟ ଉପରେ ମରି ପଡିଛି ଲୋକ ଅଛନ୍ତି ସେମାନଙ୍କୁ ପଚାରିଲେ ସେମାନେ କିଛି କଥା ଠିକ କହିପାରିଲେ Or the Land Council for the petitioner and council the Land Council for the petitioner submitted that the petitioner is the father-in-law of the deceased Jinnat Hatham. The marriage of the deceased with the son of the petitioner was solemnized on 28/4/2025 and the deceased committed suicide on 15/8/2025. Due to domestic quarrel, he further submits that as per the post-mortem report, signature mark was found on the neck of the deceased, which was found to be antemortem in nature. And the death of the deceased was due to combined defect of asphyxia and venous congestion as a result of antemortem hanging. And there are no other external injury or signs of assault identified on the body of the deceased. Then counsel submits that in view of the materials available on the cannot be said that the petitioner abated the commission of crime, the commission of suicide by the deceased. And in view of his age, the bail application may be tabled at the Consular Land Council, file the certified copy of the charge sheet and the statements of the witnesses which are taken on record. Land Council for the state oppose the prayer for bail. Considering the submission made by the Land Council for the respective parties, nature of accusation against the petitioner, surrounding circumstances under which the deceased committed suicide, period of detention of the petitioner in judicial custody, and inclined to release the petitioner on bail.
Item 27.
Yes.
Non-commercial quantity of brown sugar melon, 110 grams. I was arrested on 16/9/2025.
What about the criminal antecedent?
I have a case of 2023 under section 379 IPC.
But what is your instruction?
Investigation in progress, rejection order.
Or the Land Council for the petition and Council for the state. Considering the submission made by the Land Council for the petitioner, that the petitioner is in judicial custody since 16/9/25. The quantity of the brown sugar stated to have been seized and the position of the petitioner is lesser than commercial quantity and therefore a bar of section 37 of the NDPS Act is not applicable. And after hearing the Land Council for the state, it indicates that the petitioner has got one criminal antecedent, which of course is not similar in nature. And we plan to release the petitioner on both subject conditions. He shall not indulge in any criminal activity appear before the trial court on each state allowed. Yes.
Item 28.
Charge sheet submitted 420 along with other offences, my lord.
allegation is that giving the government assurance to give government job, taken my lord 99,999 rupees. That's it.
So, charge sheet filed on 6/12/25.
Yes. On an allegation.
Allegation assurance to give government job. He has taken my lord 99,999 rupees. That is the allegation.
पैसा फेरान डिपोजिट कर दियंतु गवर्नमेंट जॉब दे देबा कोन माने
That is the allegation. And charge sheet submitted 420 by lord 6/12 charge sheet submitted.
Where is the charge sheet copy?
Charge sheet money was transferred to Karthik. Karthik has 2 antecedent, other one has 1.
What type of cases?
Salad type of cases, yesterday has been granted.
Coordinate bench granted bail.
Deposit that amount.
Some amount to loss.
No, it has been transferred to your account. It's not
Yes.
that he is having no documentary proof. And you are having similar criminal antecedent.
Good faith setup, coordinate bench, lordship indicate.
Or the Land Council for the petition, Land Council for the state, considering the solution made by the Land Council for the petition, that the petitioner is a young employee of 33 years, and the offences under which he has been charged sheeted are triable by magistrate. And after hearing the Land Council for the state, who submits that there are similar criminal antecedents against the petitioner, and in the case in hand, the petitioner has, on the assurance of giving government job, has taken a sum of rupees 99,999 rupees from the petitioner, which was deposited in his account, in the account of the petitioner. I'm inclined to release the petitioner on bail subject to condition that the petitioner shall furnish the cash security of so and so that will be kept into fixed deposit. Yes, ma'am. Okay.
Item 29.
326.
But I may pardon.
Yes.
Connected to the custody 1311. Mo account kichhi jaye. 28.
The account ki jayeni?
No. Only Karthik.
Acha. Considering the submission made by the Land Council for the petition that the petitioner is in judicial custody since
13/11/2025. Pursuant to order passed by the Assembly.
13/11/25.
Pursuant to order passed by the Assembly.
In view of as he surrendered in the court below, as per the order passed in an anticipatory bail.
Yes, my lord. ABL APL 11173025. And
that charge sheet has been submitted 6 years earlier, and that no amount has been transferred to the account of the petitioner, and the entire money has been transferred to the account of the co-accused Karthik Behera, alias Raja, alias Anna. I'm inclined to release the petitioner and magistrate tribunal of impact is like that.
Okay.
They are allowed. Next.
Item 30.
Item 29. The case under section 302. I have filed the copy of the charge sheet and deposition. Okay. This is the third journey. I only pray that out of 37 witnesses, only 2 witnesses have been examined by. So I pray for an interim bail on the ground of I have filed an IA also.
the learned counsel for the petitioner submits that the petitioner is in judicial custody since
since 13/5/2023.
13/5/2023, and even though the case has been committed to the Court of Session since 2023, and trial has commenced, but only 2 witnesses have been examined. Let a report be called for from the learned trial court, and for such purpose, file be placed before sworn. So yes, next.
Item 30.
May I please? Alleged offense 3096, my lord, 331, 374, that is 394, 453, 413. Arrested in one case and remanded in unknown affair was lost. Allegation they have broken the house and took the household
There are
activity.
other criminal cases as
One similar
331, 4, 304.
ସେଥିରେ arrest କଲେ ଏଥିରେ remand
457, 3. Who accused it?
when they are in custody in another case, they confess they are guilty. They have committed this case.
You are taken on remand in this case?
Yes, my lord. On 5/9/25.
5/9/25.
Yes, my lord. Charge sheet submitted 2/11/25.
Charge sheet under section?
Under section, same section, my lord. 3096.
The copy of the charge sheet is
Yes.
3096, 331, 4, 317.
What are those IPC offenses?
Offenses 394, 457, and 411. Receiver of stolen.
Counsel for the petitioner and counsel for the state, considering the submission made by the land counsel for the petitioner, that the petitioner is in judicial custody since 5/9/2025, and he has been charge sheeted under section 309(6), Article 31(4), and 317(4) of BNS. And after hearing the learned counsel for the state, who submitted that there is one criminal antecedent against the petitioner of similar in nature, I am inclined to release the petitioner on bail subject to condition that he shall not indulge in any criminal activities and appear before the learned trial court on his state violation of any terms and conditions and entail cancellation of the
Pardon my lord. That in that item 29, there is also an IA 109495.
That will be after that report is received. Yes, next item 31.
Item 31.
May I please? 103 clause 1 and 238 clause 1 and 35 of the BNS, madam. 103 is there, madam.
There is the copy of the.
Yes, I have the case then.
Madam. The date of FIR, madam, 7th January 2025, and date of occurrence 6th January 2025 night, and name of the deceased, madam, Umakanta Harijan, and he died on 7th January 2025. Madam.
How many you are in custody since when?
Custody since, madam,
18/9/2025.
Madam, 18/9/2025.
Now 2025.
2025. Charge sheet submitted.
Yes, madam. Charge sheet submitted. Charge sheet submitted on dated 30th.
So what are the offenses?
103 clause 1, 35 and 238 clause
103(1) is murder.
Madam.
3 bracket 5 is 34.
238 clause A, that is madam 201.
238 bracket 1.
That is actually. And in between, madam, in another main case, 11 witnesses have been examined, and along with the wife of the deceased, who is the eyewitness in this case, madam.
No, in this case, trial has commenced.
In this case, main case, madam, the present petitioner and others are absconders.
Okay.
And in the similar footing, madam, other accused person released on bail. Other accused released on bail in this case.
No, who is the deceased? What is the name of the
name of the deceased, madam? Umakanta Hari.
Umakanta
Hari. And date of death 7 January 2025.
Occurrence केवल है
6th January 2025 at night
6th January 2025 और डेथ ला था next दिन
next day.
No, on the spot he died.
हाँ
On the spot he died.
No, 7 January 2020.
राती 12ଟା ବେଳେ occurrence
अब बाकी eye witnesses are there.
One eyewitness the wife of the deceased man.
ना कौन कौन
Santula Janni, alias Damun.
हाँ
Santula Janni, alias Damun.
Janni
Janni.
संपूर्ण Janni.
Yes.
This is not what
Umakant Hari.
कौन कौची संतुला Janni.
She became
Half time. The deceased went to her house to recharge his mobile phone. The villagers and her husband thought that they were in an illicit relationship and thereafter assaulted him and died.
Yes, who said you are telling that he has been examined in the trial court?
Yes, ma'am. That is
Where is the evidence of?
that is in para 4 of the order.
No, where is the deposition copy?
Deposition copy.
Bring out. The learned counsel for the petitioner submits that in the connected the co-accused persons
one person.
The trial of the co-accused has already commenced and some witnesses have been examined, including the sole eyewitness to the occurrence, Santula Jani, the widow of the deceased, Umakanta Harijan.
No,
she is not the widow. The deceased went to her house to recharge his mobile phone.
So deceased is not the eyewitness is not the widow.
No.
Eyewitness was Santula Jani, and he may be given some time to produce the deposition copies of the witnesses, examine and produce hand over the same to the Land Council for the state put up this matter after Christmas holidays.
Both the case.
Not equal.
Item 32.
32 melody after the state.
Yes, next.
Item
You have
30.
got the case diary?
Yes, ma'am.
All right. CD available.
Item 33.
Yes, there is that.
And a commercial one. Non appears for the appellant. Land Council for the state submits that he has received the case diary after winter holidays.
Item 34.
Lordship, alleged offense under section 103 subclause 1.
CD criminal anti-agent. Next.
5.
May I please order? 20 with 7 kg of ganja. Custody since 5/11/2025.
Right. 5/11/25. 7 kg ganja, lesser than commercial quantity. Bar not accessible. Allowed. Next.
Two sub items. One sub item.
ये डेट समान custody date.
Custody date same.
Next.
Item 36.
May I please your lordship? This is a case under section 25 1 capital A 29 and 35 of Arms Act. And in this case, I am in custody since 20/8/2025. The allegation is that on patrolling duty, the complainant got an information that some illegal arms has been selling at the parking area of Samlesri Mines, Brajraj Nagar. And open on the chest, the complainant found one pistol from Sangram Kalet and Bikaswara. Nothing has been seized from my possession. Sir, in this case, charge sheet has been submitted on 8/10/2025.
In the rejection order, in paragraph 5, it says that one country-made pistol, single shot, 2 live ammunition, and one country-made pistol and 2 live ammunition have been seized from the exclusive possession of the co-accused.
Co-accused.
They failed to produce any document in support of so and so. So, how many cases are there?
Next, there is no print, only one because next one print.
No, I get to.
Saroni, more not sir, कौन सी antecedent?
Fine. Now, what about what he makes the submission that so far as this pistol and
that
this
is
live ammunition are concerned,
Sangram Kalet and Bikaswara.
Seized from the
They are purchased for this court.
Are the Land Counsel for the petitioner. What is your good name, Land Counsel?
Sir, Gopal Prasad Lal.
Mr. Gopal Prasad Lal, Land Counsel appearing to the virtual High Court. Kota appear Purjandi?
I am from Sambalpur, sir.
Considering the submission made by the Land Counsel for the petitioner, that the petitioner is in judicial custody since 28/2025. In the meantime, on completion of investigations, charge sheet has been submitted. Same offense.
Sir.
25 bracket 1A oblique 29 oblique 35 of the arms act. And the further submission that neither the pistol nor the live ammunition was seized from the petitioner, and it was seized from the accused, and that the petitioner has got no criminal antecedent, and after hearing the Land Counsel for the state, who has not disputed the submission made by the Land Counsel for the petitioner, I'm inclined to release the petitioner. Allowed.
Oblige me, Lord.
Item 37.
This one on behalf of Mr. Nigam Minor. Offense under section
37 criminal antecedent.
Most of file a comprehensive affidavit. Land Counsel for the state on
rejection order.
Point out from the rejection order that there are 37 numbers of criminal antecedent against the petitioner, and he is yet to receive the case diary. Stop. The Land Counsel for the petitioner seeks for an adjournment to obtain instruction relating to the status of such cases and file a comprehensive affidavit. List this matter on such and such date. Yes, next.
Item 38.
20B2C, coordinate bench has disposed of the page 16.
Case diary.
But I may pardon that one thing, my lord. Page 16 earlier order coordinate bench has passed in BLAPL to renew their prayer after filing of charge sheet. I pray day after tomorrow if possible.
Adjourn matter. The Land Counsel for the petitioner submits that earlier the bail application was rejected by coordinate bench.
On 24/6/25.
This will have before appropriate bench. Yes. Case diary is received for them. Yes, next.
And I may pardon if possible next.
No, I cannot fix the date. Yes. Next.
39. 20B to the socket. This case.
6 kg. And who do you achieve a 30?
Paragraph 1.
Paragraph 1.
Informed order page 11.
No, no, order को पता है.
Page 11 top containing sheet paper. Page 11.
अच्छा, out for study.
So 11, 12, 25.
For study ହେଲା 11/11/2025. 6 kg ganja lesser than commercial quantity part not applicable allowed. Yes.
Connected matter is
Same.
Same.
Date same.
Yes.
Data allowed. Yes.
Item 40.
May I please lordship?
Required.
Is on section 302 IPC. The eyewitnesses in this case, my lord, namely P 4 and 5, they have been examined by the trial court. But
No,
they
he's not having the case diary with him, so he has to verify whether those are the two only eyewitnesses or somebody else. Look, the hard Mr. Om Prakash Sarang, Land Council, appearing through the virtual High Court Enkana, Mr. Council for the State, Land Council for the State, the case diary is not available, and the case will be taken up on some other day. Please, this matter such and such date at end. Yes, next.
41.
May I please your lordship? But 111 clause 4 of PNS along with 25 of Harms Act. My lord, so far the allegations are concerned, my lord, the present petitioner along with co-accused persons assembled together for arranging customer for sale of illegally firearms, my lord. And 3 persons apprehended the spot.
How many cases are there?
My lord, so far as the present petitioner is concerned, there is 4 antecedent of year old.
File the comprehensive appeal. The
connected item I have given taken argument that there are 2 antecedents, and in those 2 antecedents he has already released on bail.
Current counsel for the state has pointed out the rejection order that there are 4 criminal anti-scams against the petitioner. We let the current counsel for the petitioner obtain instruction relating to the status of such cases and filing comprehensive affidavit. And the state councils have also produced the case diary. Yes, second antecedent.
2 antecedents, but I have taken instruction and I have taken argument in the paragraph 7 that yes,
there are 2 criminal antecedents which is bail. He has to produce the bail out of the office.
Item 42.
May I please? A charge sheet submitted, who accused already granted bail, that connected record has come.
Yes, there is
Charge sheet submitted, your lordship kindly bear with the certified copy of the charge sheet. Who accused already granted bail, allegation is that the petitioner fired from gun, my lord, that was not hit to the informant. And in the meantime, charge sheet submitted, and the petitioner being one case that has been mentioned in rejection order, page 14. Custody since, my lord, 12/9/25.
to attempt to commit murder.
Aye.
What is the period of detention?
12/9/25 is in custody. More than 3 months.
Yes, Mr.
Yes, ma'am.
The Land Council for the petitioner, Land Council for the state. Land Council for the petitioner submits that the petitioner is in judicial custody since 12/9/2025. In the meantime, on completion of investigation, charge sheet has been submitted under section Sahil Shabis bracketed, 296 115 bracketed, 109 bracketed 1, 351 bracketed 3, and 3 bracketed 5 of AMS, and section 25 bracketed 1 hyphen capital B bracketings and another small a, and section 27 bracketed 1 of arbitrary. He has filed the certified copy of the charge sheet and some statements of some witnesses which are taken for land council further submits that nobody has sustained any injury. He on injury time has sustained any injuries, and therefore the bail application may be favorable. Land council for the state oppose the prayer for bail on account. There is one criminal antecedent.
Yes, that reflected in the rejection.
There is one criminal antecedent against petition. Considering the submission nature of the application against the petition, since no one has sustained any and taking the wrong period of detention in initial custody and inclined to the petition around bail, subject to condition that he shall cooperate with the investigation. He shall cooperate, he shall not temporarily evidence and appear before the land trial court of this state, in the case shall be posted for trial. Violation of any terms and conditions shall entail cancellation of bail allowed.
Obliged.
Item 43.
Document on the section
1031
1262.
Yes, there is.
There is.
Wait. Quebec custody gale
6/10/2025. 6/10/2025.
Charge sheet helan.
Charge sheet.
Charge sheet helan.
Here is the case only feast and peak bills.
Charge sheet. Land council for the state takes some time to obtain instruction regarding submission of charge sheet. Next.
Item 44.
Yes, Mr. Panda.
My lord, in this case, I am receiver of the stolen property, my lord. No antecedent. Page 13 rejection order.
Debate ruling.
Custody since 25/10/25.
First item put the criminal antecedent.
Or the current council.
Sub item 38 criminal.
Council for the petitioner. Consider the submission made by the land council for the petitioner. The petitioner is in the custody since 25.
My lord.
And charge sheet helan and investigation charge.
Investigation.
And investigation has made substantial progress. And there comes to magistrate tribunal offense.
Magistrate.
And the offenses are tribunal by magistrate. And after hearing the land council for the state who submitted that there is one criminal antecedent.
First item one criminal antecedent.
First item one criminal antecedent. I am inclined to release the petitioner on bail. Second
Second 38 criminal.
38. Yes, 38 criminal antecedent is a file a comprehensive affidavit after Xmas holidays. Next.
Hello, and there are two matters, and Haki alias Aksar Naik is one other accused. He has one.
Aksar Naik kitachi.
Hello, what a case re?
Wait.
Including this, my lord.
So, Quebec Island.
Custody 7/11/2020.
The second type of view, DLAPL 12677. 7/11/2025. Offense trial by magistrate and submitted that one criminal activity.
True.
Item missing.
Yes, my lord. So, either arrestation, I would Samal PS case number.
Yes,
320 remand.
It is allowed. Magistrate allowed. Next.
That is allowed.
The only one that Vikas Naik remains, whom you said that there are 38 criminal activities. Next.
Item 45.
My pleasure, Lord. Corresponding offences under section 341, 323, 302, 34 IPC matter. Petitioner is in custody 13/8/2025. In the meantime, charge sheet has been submitted.
You want to hear case
Charge sheet has been submitted 9/11/2025.
କଷ୍ଟଡି କେବେଠୁ ଅଛନ୍ତି?
13/8/2025.
13/8
ଆଜ୍ଞା
2025 ଚାର୍ଜ ସିଟ୍ ହେଇଗଲାଣି?
9/11/2025.
କଣ ଅଫେନ୍ସ ହେଇଛି?
Offense 302.
No, no.
मतलब 126 clause 2 of
BNS
yes, my lord. 126 clause 2.
126 2 ତାପରେ
115 2.
115 2
103 clause 1. 3(5) of the BNS.
What is the name of the deceased?
Name of the deceased, my lord, Sheikh Laltu.
Laltu?
Yes, my lord. And the main allegation again.
Oh, wait. Date of occurrence?
Date of occurrence, my lord, 12/8/2025.
12/8/2025 ଆପଣ ତା ନେକ୍ସଟ ଦିନ ଆରେଷ୍ଟ ହେଲେ?
Yes, my lord.
ଆଇ ୱିଟନେସ୍ କିଏ କଣ?
Eyewitness, my lord, I am getting Mangal Godai.
ଆଇ ୱିଟନେସ୍ ମଙ୍ଗଳ ଘଡେଇ?
Yes, my lord. I am reading the relevant person.
କଣ?
12/8/2025 ସନ୍ଧ୍ୟା ସମୟ ପାଖାପାଖି 6:30 ରୁ 7ଟା ମଧ୍ୟରେ ମୁଁ ଆମ ବାଗାନ ଯାଉଥିବା ସମୟରେ ଦେଖିଲି କି ସୁମିତ ଟି ଷ୍ଟଲ ଛକରେ ଆମ ବସ୍ତିର ଶେଖ ଲାଲଟୁ, ଶେଖ ଆଜାଦ, ଶେଖ କୁରବାନର ଗଣ୍ଡଗୋଳ ଚାଲିଛି ଓ ମାରପିଟ ଚାଲିଛି। ଆମେ ସବୁ ସେମାନଙ୍କୁ ବୁଝେଇ ସୁଝି ଘଟଣାକୁ ଶାନ୍ତ କଲୁ। ସେଠାରେ ଥିବା ଏକ ହୋମଗାର୍ଡ ଦିଦି ମଧ୍ୟ ଆସି ସେମାନଙ୍କୁ ବୁଝେଇ ଥାନାକୁ ଯିବା ପାଇଁ କହିଲେ। ଏହି ସମୟରେ ଶେଖ ଲାଲଟୁ ରିଙ୍ଗ ରୋଡ ପାର ହେଉଥିବା ସମୟରେ ହଠାତ୍ ଶେଖ କୁରବାନର ପୁଅ ଶେଖ ମୁସ୍ତାଫା, ଯାହାର ଡାକ ନାମ ରାଜା, ହାତରେ ଏକ କାଠ ବାଟାମ ଧରି ଦୌଡ଼ି ଦୌଡ଼ି ଆସିଲା ଓ ଶେଖ ଲାଲଟୁକୁ ମୁଣ୍ଡରେ ପିଟିଲା। ଏହା ଫଳରେ ଶେଖ ଲାଲଟୁ ରାସ୍ତାରେ ପଡ଼ିଗଲା ଓ ସେନ୍ସଲେସ୍ ହେଇଗଲା। ତାପରେ ରାଜା ସେଠାରୁ ବାଡ଼ି ସହ ଦୌଡ଼ି ପଳେଇଗଲା। ତାପରେ ଶେଖ ଲାଲଟୁର ଭାଇମାନେ ଶେଖ ଲାଲଟୁକୁ IGH ମେଡିକାଲକୁ ନେଇଗଲେ। ଡାକ୍ତରମାନେ ଶେଖ ଲାଲଟୁକୁ ମୃତ ଘୋଷଣା କଲେ।
So, whose son assaulted?
The petitioner number 2, Sheikh Kurban, son of the Sheikh Kurban.
What is the cause of death as per the PM report? There is a counter case.
Yes, my lord. So first, the petitioner number 1 filed the case against the deceased and 2 other persons. Thereafter, the second case was registered against me. In the counter case, both the petitioner were injured, my lord.
Antemotum fatal. No find that the cause of death of the deceased was due to antemotum fatal, especially head injury.
Yes, ma'am.
Including other bodily injury. Time since death is 24 hours of the okay.
And no antecedent of the petitioner.
Part the counsel for the petitioner and counsel for the state. And counsel for the petitioner submits that the petitioners are in judicial custody since 13/8/2025 and they have been charged sheeted under section 126 bracketed 2/115 bracketed 2, /103 bracketed 1/3 bracketed 5 of BNS. The occurrence in question took place on 12/8/2025 and it's a case and counter case. And the eyewitness account of one Mongol Ghadi indicates that there was disturbance between the petitioners on the one hand and the deceased on the other hand. And at that point of time, the co-accused Sheikh Mustafa came to the spot with a split wound and assaulted on the head of the deceased. And as a result of which the deceased was shifted to the hospital.
Yes, ma'am.
And expired. Same day or for
Same day.
On the same day. He further submits that it's a case and counter case, and the appellants have the petitioners have also sustained injuries.
it is argued that in view of the materials available on record and since the main role has been attributed against the son of petitioner number 2, the bail application of the petitioners may be favorably considered. And counsel for the state has produced the post-mortem report, which indicates that the cause of death of the deceased, S.K.Sahoo, was antemortem. And the head injuries are fatal, including the other bodily injury. The land counsel for the state faced the statement of eyewitness Mangal Gade. Considering the submission made by the land counsel for the respective parties, since the main role has been attributed against the accused Mangal Gade.
No, Sheikh Mustafa.
Sheikh Mustafa.
Alias Raja.
Mustafa. Taking into account the nature of accusation against the petitioner and their period of detention in judicial custody, I'm inclined to release the petitioner on bail allowed. Next.
Item 46.
May I appeal? Petitioner is custody since 4/11/2025, my lord. Offense order 331/4/305A of PNS, my lord. For corresponding section
331 out of
305, corresponding section 457/380 says.
Table
4/11/2025, my lord. चोरी 15,000 टंका एडजस्ट भागी नहीं गले.
Are the land counsel for the petitioner and counsel for the state considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since 4/11/2025 and the offences are payable by magistrate and the amount is
15,000
in question. The stolen amount, stolen cash is of rupees 15,000, out of which 13,100 has already been
recovered from the main accused,
from the co-accused. I'm inclined to release the petitioner on bail allowed. Next.
Item 47.
Stored since 7/11/25. The petitioner is the receiver of stolen property.
309.
309 robbery.
Robbery. How would it
317(2). Stolen property.
317 bracket 2. Dishonestly receiving the stolen properties. On are the churi?
Gold chain and the petitioner is the receiver of the gold chain.
Land counsel for the petition and counsel for the state. Considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody 7/11/2025 and the offences are triable by magistrate and the allegation against the petitioner is the receiver of the stolen property. And after hearing the land counsel for the state, criminal antecedent? There is no criminal antecedent against the petitioner. I'm inclined to release the petitioner on bail allowed. Next.
Item 48.
Case matter agent petitioner is the banking assistant of Bolangir Cooperative Bank matter against allegation that he has causing loss of rupees 8,34,000 in the year 2017 and 18. As per the audit report, he has not disclosed that opening balance in that year of 8 lakh and something as opening balance, for which FIR has been lost in the year 2025.
You are still in service, but 61 years ହେଇଗଲାଣି ଦେଖୁଛନ୍ତି ଆପଣଙ୍କର ଏଜ୍ ଦେଇଛନ୍ତି ଯୋଉ ଟେକ୍ସରେ ଏଇ ଯୋଉ ଫର୍ଷ୍ଟ ଟାଇପ୍ 61 years you are PF secretary na, that means you have already retired.
Yes ma'am. Thereafter 2017-18 ରୁ 25 ରେ ସେମାନେ assessment କଲେ ଯେ opening balance ଦେଇନି when I was
କଣ ଆସିଲା
ଏଜ୍ ଦେଇନା
rejection order ନାହିଁ ମୁଁ ଏଠି ସବୁ
ଇଏ ହଉଛି ଇଏ ଥିଲା କଣ
secretary of Hon'Ble cooperative society. Initially he was a bank office ମାନେ bank ରେ appointment ଯାଇଥିଲା secretary ହିସାବରେ ଗୋଟେ ବର୍ଷ ପାଇଁ ସେଇଠିକି Hon'Ble ତାଙ୍କର deputation
investigation of the case for the documents mentioned with funds was found that misappropriated tradition. All right, part of the land council for the petition, land council for the standing council for the land department. And last, land council submits that the petitioner was the ex-secretary of Hon'Ble.
Yes.
Yes,
cooperative society.
Primary
Hon'Ble PSCS
Bolangir.
And he was taken into judicial custody since 13/11/2025. And the allegation is that he misappropriated an amount of rupees 8,34,489 and
9495
894 ଲେଖା ଯେ 489
instruction ये लॉर्डशिप में काइंडली हैव अ ग्लास टू पेज
पूरे लिखा है कि अपन 8,34,489 लिखछन 480.
हाँ yes your lordship is correct because on the above ता ऊपर paragraph में it is the duty of the secretary to brought forward the closing balance of 835,954.
You found it to be this 8 lakhs one, so submits that there is no chance of tampering with the evidence and or absconding, and petitioner has retired for this. Therefore, the bail application may be further considered. Mr. Das and counsel for the standing council has produced the written instruction received from the IO of the case, which shows that the custodial interrogation is not required in the case, and the bank account of petitioner has not been freezed. The defalcated amount has not been recovered from the petitioner. The written instruction is taken on board, considering the submission made by the bank account for the respective parties, nature of petition against the petitioner, age of the petitioner, period of detention in the custody, and inclined to review the petitioner on bail subject to condition that himself cooperate with the investigation and appeared before the investigating officer as and when required on being noticed, and he shall not tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed.
Item
49.
Please, Lordship. Lordship custody from 5th May 2025. And
5.25.
again, charge
20 grams really?
20 grams from 4 accused persons. From the present petitioner, 10 grams have been seized.
Considering the submission made by the land council for the petition, the petitioner is in judicial custody since 5/5/25, and the quantity of brown sugar taken been seized from the possession of the petitioner is 10 grams, which is lesser than commercial quantity, and therefore bar under section 1 so is not applicable. And after hearing the land council, for the state. Our criminal antecedent that he has no criminal antecedent. I am inclined to release the petitioner on bail allowed not indulge in any criminal activity, appear before the land and trial court on each date to which the case shall be posted for trial. Violation of any terms and conditions shall the cancellation of bail. Yes, next.
Grateful Lordship.
Item 50.
I may please, Your Lordship. The petitioner is in judicial custody since
376-2N and 376D. 11 criminal activity.
Achha, the Learning Council for the petitioner, a state service, that there are, he has received the case diary, which reflects that there are 11 numbers of criminal antecedents against the petitioner. Let the Learning Council for the petitioner obtain instruction relating to the status of such cases and file a comprehensive affidavit to that effect. Raise this matter after Xmas holidays.
Millard.